All right. Appreciate your patience. We've had a lunch dilemma. So I've been asked to speak on the need for future FOIA legislation, and what I want to talk about are open meetings and the quandary that we find ourselves in with regard to open meetings under our Freedom of Information Act. Particularly, the Supreme Court has really confused the issue. So I'm going to take you kind of through the process of what's happened with regard to our open meetings in Arkansas. For many years, in both Attorney General opinions as well as Supreme Court opinions, the Pickens opinion, this quote appears. In essence, says that the conduct of our public business does not merely consist of the final result reached, but also is rather a spectrum including all phases of the process how the result is achieved, including the deliberations, the discussion, and the information gathering. Accordingly, the Freedom of Information Act gives the public the right to observe the entire spectrum, not just selected parts. And in literally case after case that I've been involved with, we've seen that because of technology in some instances, in other instances just conversation, but emails, text messages, and other electronic media, we're seeing that many of the discussions and deliberations are occurring outside of public view. There we go. The mayor of El Dorado case was one that, in terms of meetings, has been relied on over the years. The Supreme Court ruled that FOIA applies to unofficial meetings called to discuss any matter which foreseeable action may be taken by the governing body. So when you've got, and generally I've found that these matters are generally on very heated issues or very sensitive issues. Could be the mask mandate. Recently we found that the Huntsville School Board, they were having text messages, exchanges, discussing and deliberating the mask mandate. The public needs to be aware of those. Because that is certainly, and it did happen, was a matter that would reasonably, that action would be taken on by the governing body. So many years ago, I think it was 2007, I was actually personally the plaintiff. We went all the way to the Supreme Court on an issue where, in essence, in that case, our city administrator had sent out a memorandum, and it wasn't just our problem with it wasn't just an informational memorandum. It had the result that the administrator wanted the body to achieve, and they had conversations. We took depositions of those people, and I don't think we got as you heard this morning, the facts are everything. I don't think we got all the facts when we asked about what the discussions were, but I think decisions were made, but it was hard to prove. But we appealed that case to the Supreme Court, and what the court said was, they ruled against us on that FOIA violation issue, but in their rationale, they talk about, look, it's not our responsibility. These are topics for the Arkansas General Assembly. We've seen that, and we have three legislators, representatives in the room today, and we really appreciate that. Representative Boyd, Representative Cindy Crawford, and Representative Lowry. We appreciate y'all being here. They're saying it's your job to create a definition of the word meeting. And that is so critical, because is we're going to talk about a case, another Supreme Court case in a minute. It's really muddied the water, and it's not just the citizens who are being hurt by this. It's also governing bodies. They don't have a clue as to what a meeting is. So it's the legislature's job to define the number of members present to constitute a meeting. And they had like 7 factors. We've noted 3. Whether citizen contact with one or more members is a meeting. Whether communication by electronic means is a meeting. Whether administrative staff contact for any purpose, including serving as a straw man at request of one or more members, is a meeting. So, you know, this act, the Open Meetings Act, since 1967, our city of Fort Smith made the argument that emails wasn't included in the act, so that could not be a meeting. Supreme Court, in the Wade case, which has decimated open meetings in my opinion, did clarify that issue for us, but it should be clarified by legislation, not necessarily the Supreme Court. And they admit that. We've seen this discussion, obviously, where the legislature has said, look, Governor, you're taking too much power. Well, the judiciary in this instance is trying to give power back to the legislature. June Bradshaw was a case that in Fort Smith where it was an email exchange by our 7 school board members where they elected their officers by a secret email chain. We took it, we asked for a summary judgment saying there's no genuine issue of fact. Judge Tabor granted our summary judgment stating that that was a violation of FOIA. But I'm telling you, even under those facts of that case, where 7 school board members are having an email discussion and electing the school board officers, under the Wade case that we're getting ready to talk about, that would not be a FOIA violation.